So welcome back to another video. Thanks once again for joining us. And in this video, we're going to be talking about prison sentences in drink driving cases. And we're going to be answering three main questions. First of all, can you go to prison for drink driving? Secondly, how likely is it that you'll go to prison? And thirdly, what can you do to avoid or minimize the risk of a custodial sentence, a prison sentence? So hopefully you find the video useful. Hopefully you find it somewhat reassuring. But if you are in a situation where you've been charged with drink driving and you'd like some further advice, then please get in contact. You may know by now, if you've seen any of our other videos, that all our initial advice is completely free of charge. I'm normally on hand to be able to speak with you and spend as long as you need on the phone. You'll find our contact details on our website and also in the description of this video as well. So please feel free to get in touch if you'd like to have a chat. But let's get stuck into it then. So first of all, can you go to prison for a drink driving offence? Well, I'm afraid to say the answer to that question is yes. You can go to prison for drink driving. And the reason you can go to prison for drink driving is because the sentencing guidelines say so. Now, of course, it depends upon the individual circumstances of the case, how serious that case is, any aggravating, any mitigating features as well, which we'll cover in a second. But drink driving is a summary-only offence, and that means it can only be dealt with in the magistrate's courts. Now, the magistrates can impose custodial sentences of up to 6 months for a single offence. So for a drink driving offence, you can go to prison for up to 6 months. Now, the chance of going to prison for that length of time is slim to none. I've personally, in all the years that I've been doing this, I've never heard of anybody go to prison for 6 months for a single drink driving offence. But technically, in accordance with the guidelines, the magistrates do have those powers. Now, how likely is it that you would go to prison for drink driving? Well, again, that depends upon the individual circumstances of your case. And that's why if it's something that you're worried about, then I'd always encourage you to try and seek some independent legal advice, because a solicitor can probably tell you within 5 minutes whether it's likely or not that you go to prison. You're probably more concerned about the risk of a custodial sentence if you've been in this situation previously, so if you've got previous convictions, or there's something that makes your case more serious than the average drink driving case. And that's why it might be a concern of yours. But what the court will look at are any aggravating or mitigating factors. Now, aggravating factors are factors that make the case more serious. Mitigating factors are factors of the case that make it less serious. And let's cover some of the most common aggravating factors in drink driving cases. Now, remember, these are features of a case that are going to increase the risk of a custodial sentence. So, for example, and we've touched upon it, if you've got a previous conviction for the same offence, particularly if that previous conviction was quite recent. If you were driving and you had passengers in the vehicle, then the court might decide that you're putting other people at a risk of harm, and that makes the case more serious. And if there's evidence of bad driving, so that doesn't mean to say you have to be charged separately with careless or dangerous driving, but if there's evidence of bad driving, then that too can increase the risk of a custodial sentence. But the main determining factor as to whether a custodial sentence would be imposed is the alcohol level. Now, I'll stick a copy of the sentencing guidelines on the screen, and you can take a look at the guidelines the magistrates will use when they sentence for offences like these, and you'll see the different columns and the different rows depending on the alcohol level. Now, as the alcohol level increases, so too does the kind of penalties the court can impose. And if you look at that final row, you'll see the starting point there is 12 weeks in custody with a range of a high-level community order to 26 weeks in custody. Alongside that, massively increased driving disqualifications as well. So the court are going to consider those aggravating factors. They're going to look at those alcohol levels, and if they decide that it is sufficiently serious, then they can impose a custodial sentence. Now, we're going to return to this in just a moment, because there's a few, not necessarily tricks, but there's a few things that you can do to reduce the risk of a custodial sentence in circumstances where your case clearly falls into a category where a custodial sentence should be imposed. But turning to mitigating features, well, these are the opposite of aggravating factors. This is anything that makes the case less serious. So if, for example, you were in the vehicle on your own, then it's less serious. If there's no evidence of bad driving, let's say you're pulled over for a document check or your car showing that you've got no MOT and the officer isn't concerned about the manner of driving, again, that may make the case less serious. If, for example, you don't have any previous convictions, so you're good character, again, the magistrates are less likely to send you to prison. So have a think in your case about any aggravating and mitigating factors, and from that you can work out the risk of a custodial sentence. Perhaps even jot them down on paper, and if you can think of more mitigating factors than you can aggravating factors, that might reduce the risk of a custodial sentence. If when you jot these down on paper and there's far more aggravating factors than there are mitigating factors, then maybe that increases the risk of a custodial sentence. And the obvious one is the alcohol level as well. So much like in cases that involve high alcohol levels, if your case involves a very low level of alcohol, then that reduces the risk of a custodial sentence. I showed you the guidelines a little bit earlier on, and you'll see from those guidelines that the risk of a prison sentence in cases that involve very low levels of alcohol is slim to none. So that's probably not going to be a concern if you are only just over the legal limit. Now, I mentioned earlier, there are one or two ways that you can reduce the risk of a custodial sentence in a case that is sufficiently serious where the court could send you to prison. Now, one way is to ask the court to suspend that prison sentence. And that means they impose a period of imprisonment, but you don't actually go to prison. The court may send a person to prison for 12 weeks, but it's suspended for 12 months. And what that means is that unless you commit further criminal offences within a 12-month period, then your 12-week custodial sentence is not triggered. If you commit further offences whilst on a suspended prison sentence, then it can trigger, not in every situation, but it can trigger the suspended sentence, and then you go to prison for 12 weeks. So we can always invite the magistrates to impose a suspended sentence instead of a custodial sentence, perhaps as good reasons in your case as to why they should suspend that prison sentence. What we may also ask them to do is impose a community penalty alongside any suspended prison sentence. So it's not like you're getting off scot-free and that's it, you don't go to prison, you just get your ban and that's the end of it. If there's an element of a community penalty as well, whether it's rehabilitation activity requirement days, whether it's unpaid work, it could be a curfew, so they put a tag on your ankle. More recently we're seeing these alcohol monitoring tags being used as well, where if you have a drink, the tag will notify the authorities because it can test the alcohol in your sweat. So there's lots of different types of community penalties the court can impose, and so we might want to address the magistrates on that and invite them perhaps to impose those community penalties and to step back from a custodial sentence, or to impose those community penalties alongside suspended prison sentence as well, which can work really well. So again, if you think you're in a situation where prison is much more likely in your case because of the circumstances, then please get in touch and we'll be able to explain the ways in which we can try and reduce the risk of a custodial sentence. Now, final question that I wanted to answer is whether an early guilty plea will help to reduce the risk of a custodial sentence, a prison sentence. And in my experience, that isn't always the case. Now, it's important to know that there's two different types of penalty the court will impose if you're convicted of drink driving. You have the ancillary order and the punitive part of the sentence. Now, the ancillary order is the driving disqualification, and you may know that the driving disqualification is mandatory in circumstances where you're convicted of drink driving. The punitive part of the sentence is the fine, the community penalty, or the custodial sentence. If you enter a guilty plea early on, that attracts maximum credit, and that means that part of the sentence is reduced by 1/3. So if there's a risk that you might go to prison in your case, by pleading guilty early on, all it can really do is reduce the length of the prison sentence as opposed to the risk that you will go to prison. So if, for example, the court wants to impose a prison sentence of 3 months, for example, and you plead guilty early on, you get 1/3 credit, and therefore that means that you get a 2-month prison sentence as opposed to a 3-month prison sentence. Now, I certainly suggest that going to prison for any length of time is bad enough, whether it's 2 months or 3 months. So please don't think that by pleading guilty early on, that's going to massively reduce the risk of a custodial sentence. According to the Magistrates Court Sentencing Council, the court can still send you to prison, but it will just reduce the length of the custodial sentence. You can still go to prison, and that can still happen on a first court date if you enter a guilty plea. Now, a final point worth making is the way in which we reduce the risk of a custodial sentence by negotiating with the prosecution. Even in circumstances where you plead guilty, remember that you don't have to plead guilty on the full facts of the prosecution's case. Whenever you receive a case summary or witness statements from police officers, they'll always try and make the case sound more serious. Whether rightly or wrongly, whether true or not, whether they're exaggerating or not, the police are going to put in their statements things like your eyes were glazed, your speech was slurred, you smelt of alcohol, you were uncooperative, you were unsteady on your feet, there's evidence of bad driving. Now, when the case goes to court, the magistrates would normally hear that from the prosecutor. The prosecutor is going to read out various aggravating features because they're going to try and make the case sound more serious. Now, if you're pleading guilty at any point in the case, we're entitled to put forward a basis of plea. And that means we speak to the prosecution and we try and negotiate on what we're actually pleading guilty to. We don't have to plead guilty on the full facts of the prosecution's case. You can plead guilty on your terms. So I might speak to the prosecutor, whether that's on a first court date, Or a later stage, and I'll say, well, my client wants to enter a guilty plea, but he doesn't accept that his eyes were glazed and his speech was slurred. He doesn't accept that there's evidence of bad driving or that he was driving in the manner described by the officer. He wants to enter a guilty plea, but perhaps not on the breath reading that's alleged by the prosecution. Remember, you can always put forward your own breath reading. Sometimes there needs to be a basis for that breath reading, but sometimes there doesn't. If you're charged with a breath reading at a level that puts you at risk of a custodial sentence, perhaps the prosecution would accept a guilty plea to a lower breath reading that takes you out of that custodial sentence bracket. So we're always able to negotiate with the prosecution. Now, normally, in my experience, the CPS would usually accept those negotiations because we're pleading guilty, which is a massive convenience for the prosecution. So when it comes to the prosecution addressing the magistrates on the facts of the case, it may be that they agree not to mention certain things, not to mention things that might make your case more serious, and therefore the magistrates never hear it because they don't have access to that information. So when it comes to sentencing, the magistrates impose a more lenient sentence, a lower disqualification or a shorter disqualification, and that reduces the risk of a custodial sentence because they haven't heard of any of the aggravating features that the officer referred to in his statement or that you might find in the case summary. Now again, negotiating with the CPS would normally involve the assistance of a solicitor because I might go into court before the case gets called on and speak to the prosecutor, sound them out, and we can decide at that stage upon what's accepted and what's not accepted. If we're entering a guilty plea to a lower breath reading as well, then again, that's a little bit tricky. That may involve some scientific evidence, but again, that's not something that's too difficult in cases of this nature. So just to recap, can you go to prison for drink driving? Yes, you can, up to 6 months because drink driving is a summary-only offence. How likely is it that you'll go to prison for drink driving? Well, that depends on the individual circumstances of your case, including any aggravating and mitigating factors. That's previous convictions, evidence of bad driving, passengers in the vehicle, and the alcohol level. And what can you do to reduce the risk of a custodial sentence? Well, that's the mitigation as well. So that's your own personal circumstances, how we address the magistrates, whether we try and enter a guilty plea to a lower alcohol level, whether we try and negotiate with the prosecution to reduce the seriousness of the offence by taking out certain facts or features of the case if the CPS agree to that as well. So if you are in a situation where you've been charged with drink driving, no doubt you're extremely worried about what the outcome is going to be, please get in contact. Always happy to talk you through your options, potential defence arguments, and really what to do in that situation. Now, you might also be wondering about legal costs and legal fees. Generally, legal aid is not often available in drink driving cases, and most specialist firms don't deal with legal aid, but defending a drink driving case may not necessarily be as expensive as you might think. And I should say that we do operate on fixed fees as well, and that means that we're not charging hourly rates. So you'll find our fees on our website, but if you want more information and want to discuss a case with me, then please get in contact. Again, you'll find our contact details on our website and in the description of this video.